All right. Let's make sure everything is good. Good afternoon, everybody. Good evening. Good evening. Good evening. Uh, Let me make sure everything is organized. Give me a sec. Give me a second, y'all. I'll be right back. Oh, all right. Sorry about that, y'all. All right. Before I start the show, I need to know if everybody can hear me on a scale of 1 to 10. How good can you hear me? How good can you hear me? General jurisdiction. Okay. Let me. I'm gonna put the call-in number into the chat too. I'll do some screen sharing a little bit later. Yes, call in. I'm gonna put the call-in number in the chat so you call in. Any questions? 10, okay. All right. All right, good, good, good. Okay. Uh Good from Gary. How you doing, man? Gary, I'm so sorry. I forgot to call you. I'm working on an appeal brief, Gary, and I'm probably not gonna be done with it until probably the end of next week. So I'm trying to go ahead and get that out of the way. So that's what's taking me so long. I do apologize for that, Gary. I sincerely apologize for that. I got to finish that brief though. All right. All right. So what I'm gonna do is I'm going to do my best to try to explain to you the differences between a court of general jurisdiction, which is a court that is created by the Constitution under the exclusive jurisdiction of the common law, and then I'm going to try to explain to you what a so-called court of limited jurisdiction is, even though it's really an administrative agency due to separation of powers. Even though when you read the cases I read, you like, well, there really isn't a separation of powers. But I'm gonna do my best to substantiate that for y'all. And if it confuses you, just do your, just ask me questions. All right. I'm gonna do some screen sharing, and I'll be using case law from Alabama. All right, but do not let this case law confuse you, because what I'm going to be reading to you are principles. All right, so a lot of people, when I post cases on my YouTube channel, like I might post like a case citation, then I'll post the case where I read it at. Okay, I don't care what the case held. I don't care what the disposition of that case. I don't care about that. I post it for the principles, because this is the stuff that I'm trying to get y'all to understand, or the principles. Once you understand principles, you really ain't really got to do too much work other than reading and trying to just try to ascertain what they mean, or try to get a better understanding of what they mean. But the only way you're gonna do that is you're gonna have to read cases. I don't know what else to tell you, because that's all I do is read cases. That's all I do. Um, so let me go ahead and jump right into this right quick. I'm about to turn the screen share on right now. Um, if you want to call in, press 1. We'll try to keep it at 10, maybe 15 minutes per call, something like that. So I'm gonna go ahead, turn the screen share on, and I'm just gonna jump right into it. Uh, let's go down right here. Now, these are the cases that I'm about to show y'all. I got all of these cases. I've done plenty of videos on these cases. All right, we got the screen share on, so let's get to it. All right, let's see. And if these like if this live video don't help you, then you can go. Let me open up another link, and let me show you where you can go on my YouTube channel and watch this, because I already did videos on this. I think I did videos on this almost a year ago, maybe. And this is what I'm going to be talking about tonight. I did videos on this stuff a while back. I'm going to show you where the videos are, so you can go back and just watch them and listen to them. Let's see. This one, you need to watch this one, because I'm going to be talking a little bit about both of these videos right here tonight. You need to go and watch both of these videos. Where is it at? You need to go and watch this video. I might play this video tonight just to give y'all an understanding of the distinction between the two. Or if I can find the case, I might read it tonight, but it's kind of a long case, so I don't want to really get too much off point. But this is a really good video right here. This video right here tells you who is truly sovereign and who is not. That's why I titled it "The People versus the Legislature," because the legislature, for some reason, they just think they're the people for some reason. And the other video that you need to watch, this one right here, they're not courts, they're administrative agencies. And let me direct y'all to one more, and then we'll go ahead and start. I think this video is going to help you out a lot. This one right here. You're in an administrative agency exercising plenary power. Generally speaking, that's what it is. The only reason why I say it has plenary power is because it's really the legislature that gives it the authority to do, in other words, the jurisdiction to do what it wants to do. And the legislature over their administrative agencies, they have plenary power. The administrative agencies do not, per se, in themselves have plenary power. The legislature, because they created it, they have plenary power to almost give these administrative agencies, certain jurisdictions. All right, but no matter how much authority that they give them, these are still inferior so-called courts, all right, because of so-called separation of powers. So let me get back to here. All right, so we're going to talk about subject matter jurisdiction. All right, so-called courts get subject matter jurisdiction in two ways, and that is either the Constitution, okay, or a statute. That is it. They do not get subject matter jurisdiction in any other way. That is it. So let's go ahead and start. Jurisdiction, because a lot of people, they misconstrue these terms. Jurisdiction, based on my reading and understanding of jurisdiction, is, generally speaking, it's not a geographical area. It's not. It's just the authority to do something. That's really what it is. Venue deals with a geographical area. Venue. So I'll explain a little bit of what I was just about to say a little later. Let me go ahead and finish reading this. Jurisdiction is a court's power to decide a case or issue a decree. The power is derived from the Alabama Constitution and the Alabama Code, and then there's the case right there, blah, blah, blah. Subject matter jurisdiction refers to a court's statutory or constitutional power. I want y'all to think of this constitutional power as synonymous with common law power. And I want y'all to think of this statutory jurisdiction as admiralty or maritime, one of those two. Ain't no statutes in equity and ain't no statutes in common law. There aren't any. All right. To adjudicate a case. Let me read that over. Subject matter jurisdiction refers to a court's statutory or constitutional power to adjudicate a case. There's the case right there. You can read it in support of that contention. All right. Subject matter jurisdiction of Alabama courts is conferred only by the provisions of the Alabama Constitution and statute. So I want y'all to read it like this. So let's say we're in Kentucky. So I'm going to say subject matter jurisdiction of Kentucky courts is conferred only by the provisions of the Kentucky Constitution and statute. Let's say we in South Dakota. Subject matter jurisdiction of South Dakota courts is conferred only by the provisions of the South Dakota Constitution and statutes. So on, so on, so on, and so on. That's how they get subject matter jurisdiction. All right, but there is a distinction between subject matter jurisdiction of an inferior court and subject matter jurisdiction of a superior court, so-called court anyway. There is provided in every county in the state. Give me a second, y'all. Be right back. What? Sorry about that, y'all. Got a little interrupted. Probably lost my train of thought. But anyway, I think I was about right here. So, there is provided in every county in the state a circuit court with all the jurisdiction and powers that are conferred on the circuit court by the Constitution and laws of this state. Now that right there that's confusing me. So I'm gonna have to study that a little bit more because it sounds like what I think it sounds like, but I'm not sure. We have recognized that this court can only act within the jurisdiction conferred by law. Oh, well, they just threw. I know exactly what they mean by that. When you see this term right here, by law, that means they're talking about a statute. All right, and this cannot be enlarged by waiver. By waiver, or by the consent of the parties. So I think this means exactly what I think it means. I'll tell y'all in a little bit if I don't forget. All right. So now we're going to distinguish superior courts, aka constitution courts, aka common law courts. Because common law courts are here, they still exist. I do not let nobody tell you that they don't, because the entire government of each so-called state was founded upon the exclusive jurisdiction of the common law. The Constitution, all of that stuff is. They don't want to tell y'all this stuff, but you got to do your research. But aside from this objection, let me make this a little big. I'm sorry, y'all. All right. But aside from this objection to petitioner's claim, the courts of this state are not only divided into courts superior and inferior, they are of different characters. Some are established by the Constitution itself, that is, by the people. All right. The people created their government under the exclusive jurisdiction of the common law. All right. They do not depend on legislative enactment for existence. Let me read this again. I got to read this again. All right. I got to read this again. Let me see. But aside from this objection to petitioner's claim, the courts of this state are not only divided into courts superior, aka general, and courts inferior, aka limited. They are of different characters. Some are established by the Constitution itself, that is, by the people. They do not depend on legislative enactment for existence. They are created at the same time and in the same way with the legislature itself. They are of the same grade in the sovereign power. They are a constituent branch of the government itself. The government under the Constitution is not complete without them. And I'm going to stop right there. And I'm going to get back, I'm going to read it again. All right. So what this is saying is, even if the legislature does not create any courts, the system of government is still complete. That's exactly what that means. And I'm gonna read y'all another case that says that, but it says it in another way, and it's gonna blow y'all minds if you're not familiar with this stuff. This is why you gotta read. Let me go and check the chat right quick. One is Constitution that they have to afford your rights. All right. Let's get back to it. Make sure if y'all haven't already hit that like button for me. I would really appreciate it. Hold on, what you say, SG? Let me get back to it. Bylaws. Yeah, I agree with that, SG. I really agree with that. All right, let's get back to it. The government under the Constitution is not complete without them. That means if the courts of general jurisdiction, meaning the superior courts, aka Constitution courts, they take aka common law courts. If these courts are not created, that means the government is not complete without them. But the legislature, we don't need those. That's what they're saying. We don't need those. I'm not saying they're a bad thing. I'm just saying, you know, we can still have a government without those. All right. But anyway, they are a constituent branch of the government itself. The government under the Constitution is not complete without them. These are, and this is an old case, y'all, so they probably changed some of this stuff. All right. But this is an old case, but I just want to read this stuff to y'all. These are the Senate sitting as a court of impeachment, the Supreme Court, the circuit courts, the chancery courts, and the courts of probate. Alabama Constitution, 1867. So right now they have an Alabama Constitution of 1901. So this is old, all right? So 9 times out of 10, they probably changed some stuff around. Okay. But anyway, these principles still apply. These courts do not owe their existence to the legislative power. What? Let me read that again. This does not just apply in Alabama. This applies everywhere where this principle is applicable. To the extent that your state constitution is creates what do they call superior courts of general jurisdiction. Is what I'm trying to say. These courts do not owe their existence to the legislative power, and the legislature cannot dispense with them or abolish them. What? I wonder who can do that. I wonder who can abolish them or dispense with them, or I wonder who can do that, y'all. Let's see what the judiciary says about that. Let's see. They are emphatically the people's courts, and they proceed directly from the sovereign will. I just wonder who they talking about, y'all. I wonder. They constitute a coordinate and independent department of government. And there is no other department of the government that can abolish them. The people alone, in who is the ultimate sovereign power, can do this. They are each, in their way, constitutional elements of the state sovereignty itself, as represented in the government. The people are a coordinate department of the government. There are 4 branches of government. All right. The highest branch of government is the people. I don't care what they say. They can lie to y'all. They can't lie to me. They can lie to you. They can pull some of this stuff over y'all, like in my video about that right to travel stuff. Man, anyway, I'll talk about that later. But anyway, they're not gonna get this stuff past me, because I understand principles. All right, principles. Let me see. Let me see. I'm gonna read this again. They are each in their own way constitutional elements of the state sovereignty itself, as represented in the government. There are other courts. I wonder what they talking about. There are other courts. Let's see what they talking about, y'all. Called in the Constitution inferior courts of law and equity, which the General Assembly, which is the legislature, may from time to time establish. These latter courts derive their existence from legislative enactments. They are creatures of the lawmaking power of the state. Now I want y'all to pay attention to something. All right, the supreme, the ultimate power. Let me rephrase that. The ultimate lawmaking power does not belong to the legislature. The ultimate executive power does not belong to the executive. The ultimate judicial power does not belong to the judiciary. So who does it belong to, y'all? Who knows that? Who knows the answer to that question? Because it doesn't belong to them. This is why Justice Scalia is saying that there is no constitutional delegation of powers. You can't do that. It doesn't belong to you. So how you gonna give it away if it doesn't belong to you? It doesn't belong to you. So how are you going to authorize something else to do that? And I agree with him on that. I completely agree. Now let's go down, y'all. Let's go down. Now we're talking about inferior courts, aka statutory courts, aka admiralty courts, aka civil law courts, aka administrative agencies. All right. This we're finna talk about next. These are courts of limited jurisdiction. Right here, limited jurisdiction. I know I don't say it, but they are courts of limited jurisdiction, meaning their jurisdiction, aka their authority, is not broad. It is extremely limited, meaning they don't have broad general jurisdiction to do what they want to do to the extent that it complies with the law. They can only do what the statute authorizes them to do, just like an administrative agency. Let me get back to the chat right quick. That's right, Levant. You're absolutely right. That is absolutely right. Let me check the phone lines. All right. Let's get back to the chat. Absolutely right, Levant. Y'all can go and read these cases for yourself. I don't hide nothing. I don't hide nothing. That's why when people come on my channel trying to say this case doesn't, ain't nobody came on my channel yet that I can recall disputing me making the allegation that this case says something and it doesn't. I haven't seen a comment like that yet. Anyway, let's get to it. I'm getting a little thirsty a little bit. All right. The legislature has the power to vest, to deposit, to authorize in course of statutory creation any of the powers. I want y'all to pay attention to this, boy. Any of the powers or portions of jurisdiction of the Chancery Court or circuit courts to be exercised concurrently. I'm gonna explain to you. I did this a while back in the video. I'm gonna play a video that Yusuf did today. He said the exact same thing that I said probably almost a year ago, over a year ago when I made these videos. Pay attention, y'all. Pay close attention to what I'm about to say when I'm about to read this. Where a special authority in derogation of the common law is conferred by statute on a court of general jurisdiction, aka a common law court, aka a superior court, it becomes quad hoc an inferior or limited court, and jurisdictional facts must be shown upon the face of the proceedings. Now I'm gonna check the chat. I want to know if y'all know what that means. I'm gonna go back to the chat and I'm gonna see if y'all know what that means. Who can tell me what that means? Who knows what that means, what I just read? I want somebody to call in to the show. If you don't mind, call in to the show and tell me what that means. I'm gonna put the call in number back in the chat. Call into the show and tell me what that means. Call into the show. Y'all don't mind who somebody call. I got to make sure that y'all know exactly what that means. Because if you don't know what it means, when I tell you what it means, You're gonna be so blown. You're gonna be shocked. You're gonna be like, wow, because that was my same expression when I read that. I read it like twice, and then once I got it, I was like, wow. That does not just apply in Alabama, y'all. That is a principle. That's a principle, and it applies everywhere. Somebody tell me what that means. I'm gonna give y'all about 2 minutes to see if somebody know the answer. If y'all don't know, I'm gonna tell you. Give me a second. Let me go and get me some water, y'all. Anybody know what that means? If y'all don't know, just say you don't know, and then I'll whatchamacallit, I'll tell you. Nobody don't know. Nobody know. I'm gonna show y'all these principles, man. These are principles. Um, this case, I'm gonna see if I can. Man, I gotta get y'all to understand what this means, man. All right, I'm gonna reasonably conclude, since I haven't gotten an answer, that nobody knows what the answer is. Put it back up, please. All right, SG. Hold on, SG. All right, I'm gonna read it one more time, y'all. I'm gonna read it one more time, and I want y'all to tell me what it means. Somebody tell me what it means, because I know what it means, but I want to make sure that y'all know what it means. Man, if y'all don't know what this means, when y'all find out what it means, you're gonna be so shocked. I'm gonna read it again. I want y'all to notice that they're not calling it admiralty, y'all. They're not calling it admiralty, but they only have four authorities that they can exercise jurisdiction under, and that's common law, equity, admiralty, and maritime. That's it. This is what they calling it, though. Special authority. That's what they calling it. That's what they calling it. But anyway, I'm gonna read it one more time. Where a special authority, aka statute, in derogation of the common law is conferred by statute, which is what I just said, or in other words, where a special jurisdiction in derogation of the common law is conferred by statute on a court of general jurisdiction, on a common law court, on a superior court, it becomes, what do they mean it? They're talking about this court of general jurisdiction. It becomes quad hoc an inferior or limited court, and jurisdictional facts must be shown upon the face of the proceeding. Who knows what that means? Can somebody please tell me what that means? Let me see if I got anybody calling. All right, ain't nobody call in yet. All right, sorry about that, Levant. All right, so let me explain this to y'all. Okay. All right. There are no statutes in common law, and there are no statutes in equity. All right. You do not need statutes to invoke a court's jurisdiction in order for it to do something. You don't need statutes. All right. However, let's say you are in a court that was created by the Constitution. Let's say you're in a superior court of whatever county. This is a superior court of general jurisdiction, so it's a common law court. All right, so because it's a court of limit, I'm not limited, because it's a court of general jurisdiction, its authority is broad, so it can hear all cases, meaning it can hear cases at law, which is common law, in admiralty, in equity, and maritime. All right. But when somebody files a lawsuit in that court of general jurisdiction under a statute, then it is no longer a court of general jurisdiction. What is it then? It becomes quad hoc an inferior or limited court, and the jurisdictional facts must be shown upon the face of the. They're saying that it's no longer a court created by the people. They're saying it's an inferior, aka administrative court. That's what they're saying. That's exactly what they're saying. That's why the United States Supreme Court, there are two U.S. Supreme Courts. There's one for the United States of America, and then there's one that was created by Congress. Because you can invoke the Supreme Court for the United States of America's original jurisdiction under the Constitution, or you can do it under a statute. If you do it under the Constitution, that is under the exclusive jurisdiction of common law. But if you do it under a statute, it ain't common law jurisdiction. And it's limited as to whatever the legislature says it can do. Is this making sense for y'all? And they doing this everywhere. They doing this everywhere. Yes, SG. That's exactly what it is. It's no longer a court of general jurisdiction. Once they start exercising original jurisdiction, supervisory jurisdiction, or appellate jurisdiction under a statute, then it's a court of limited jurisdiction. It's a legislative court. It's an administrative court. It's an administrative agency. That's exactly what it is. And they're doing this everywhere. They doing this everywhere, man. So this is what they doing, y'all. I don't know if y'all remember me saying this, but I done said this over and over and over and over and over and over and over. What they are doing is they are codifying common law principles, or in other words, they are bringing case law. In other words, they are codifying case law into statutes. And they're bringing it from the exclusive jurisdiction of common law. They're bringing it from one jurisdiction over into another jurisdiction, which is theirs, which is the one they have plenary power over. And then they are modifying it. They're taking out what they don't want in it. That's what they're doing. Let me let Yusuf tell y'all. Let me let Yusuf tell you. Give me a second. He did this video today.
Words, they took admiralty and copied it. That's what they do in the legislature. The legislative courts are copying everything from the common law courts, but they did it for their statutory jurisdiction. So everything looks like common law. It looks like a judge, but it's not a judge, it's an administrator. It looks like law, but it's really statutes operating with the force of law that operate within a certain jurisdiction that Congress has authority over. That authority is derived from Article 1, Section 8, Clause 17. That's their jurisdiction as far as that 10-mile square and all their insular possessions.
All right. That's what they're doing, y'all. That is exactly what they are doing. They've been doing this for a while. Appreciate that, fam. I really appreciate that. That's what they're doing, y'all. They're trying to make, just like Yusuf said, and I said this too, they're trying to make their administrative agencies look and function just like superior courts, aka courts of general jurisdiction. That's what they're trying to do. Now they could make these administrative agencies separate from courts of general jurisdiction, but they're not doing that because they want to confuse you. So what happens is the same judge of the court that was created by the Constitution is also the same executive administrator sitting in, acting under statute. And you don't know this because you don't do your research. That's what they doing, y'all. That is exactly what they doing, fam. Y'all think U.S. district courts, or you think that they have judicial power. They don't have judicial power. And all U.S. district courts are courts of limited jurisdiction. All U.S. courts of appeals are courts of limited jurisdiction. The United States Supreme Court, when it's acting under any type of statute, is a court of limited jurisdiction. It's an administrative agency. It functions just like an administrative agency. That's what they doing, y'all. I don't know what else to tell y'all. I don't know any other way to tell you, but that is what they are doing. And they're doing this everywhere. Probably so. It was probably when they merged law and equity. Um, it probably was when they merged law. I don't know. I'm just guessing. That's just my speculation. But they didn't all do it at the same time. Different states did it at different times. But let me get back to this document, and then I'll read y'all some more cases. All right. All right. In every constitution of Alabama, there has been a provision for inferior courts. Section 139, Constitution. The Constitution of Alabama made provision for inferior courts instead of justice of the peace courts in certain circumstances. Section 168 Constitution. All right. The divisions of courts recognized that common law was superior or courts of general jurisdiction, which is what I just said, and inferior or courts of limited jurisdiction, which is what I just said. Pay attention to this, y'all. Pay attention. Superior courts derive much of their jurisdiction from the common law, while inferior courts derive their whole existence and jurisdiction from the statutes constituting them, the statutes creating them, the statutes birthing them, the statutes aliving them. Hence, nothing was intended to be without the jurisdiction of a superior court. Nothing, whether of appellate or original jurisdiction, except what appeared to be so, and every presumption consistent with the record was indulged in favor of the regularity and validity of their judgments. They're talking about superior courts, not inferior courts. Inferior courts are not entitled to that presumption. While of inferior courts, no intendment was made favorable to their jurisdiction, none, because it's inferior. And any conformity to the law of their creation must have been disclosed by the records. It must show either in the affirmative or the negative on all face of the administrative proceedings. It must show in the affirmative, meaning, yeah, we got jurisdiction, or it must show in the negative. If it's in the negative, you don't have jurisdiction, you got to dismiss the case. That's the only authority you have, is to dismiss the case. That's it. Y'all hit that like button for me. Hit that like button for me. Let me go back, check the chat, check the phone lines. All right. Yeah, cool. Okay, y'all hit that like button for me. All right, now, before I start back, is this, because I know some people are new to my channel, and some people might just be new to this field at all. You know what I'm saying? Is this stuff making sense to y'all? Are you starting to distinguish between the differences between a court of general jurisdiction and an administrative agency, limited jurisdiction, a so-called court? Is this making sense? Is this helping you? I'll come back to the chat in a minute. Let's see. Where did I stop at? Okay, we stopped about right here. Such was the only division of courts of such was the only division of courts at common law into superior and inferior. It followed from the character of jurisdiction that courts exercise, and not from the subjection of the court to the appellate power of another tribunal. In the last sense, all courts of original jurisdiction are inferior to a court exercising over them appellate power. I agree with that. This court has all the elements and all the instrumentalities of a court of record of general jurisdiction within the territorial limits prescribed. It is in jurisdiction I'm sorry, it is in jurisdiction, in dignity, and machinery, in officers and process, co-equal with the circuit court. It can be termed an inferior court only because the eighth section of the statute creating it subjects it to the appellate and supervisory jurisdiction, which this court can exercise over the circuit courts and courts of chancery. So this must be an Alabama Court of Civil Appeals. Civil Appeals. As above indicated, uncontrolled by the judicial exposition, this clause of the Constitution has received. I would incline to the opinion that the General Assembly could not establish this court, that it is not an inferior court within the meaning of that term as used in the Constitution. The question was the subject of deliberate consideration in Nugent versus State, blah, 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 and it was declared that the judgments of which were subject to revision by a higher tribunal was an inferior court within the meaning of this clause of the Constitution. That is in the relation that the courts bears to the superior tribunal and the character or the extent of its jurisdiction, which is contemplated. The conclusiveness of this decision has never been questioned. It has been repeatedly acted on by the General Assembly and acquiescence in by this court. With full knowledge of it, the same provision in the same terms are incorporated in the present Constitution. We are not at liberty, therefore, to depart from it, and we must pronounce it within blah blah blah. I don't even need to read all that. Let's go down a little bit more. So I must have got okay. I got all this from the same case. Okay. It has many times been declared that it is within the providence of the legislature to establish inferior courts of concurrent jurisdiction. Concurrent, they're talking about equal jurisdiction with that of the circuit courts, and to provide for the transfer of causes for the circuit court to such inferior court. And there's all the cases, blah, blah, blah. Let's go. An inferior court within the meaning of Section 139 of the state constitution, giving to the legislature the power to establish the same, is a court whose judgments or decrees may be reviewed by an appellate tribunal, whether that tribunal be the circuit or other appellate court, blah, blah, blah. And the legislature has the unquestioned power to vest in inferior courts of statutory creation any of the powers or any portions of the jurisdiction of the court of chancery, meaning that if they want to create a juvenile court and give it some sort of statutory jurisdiction in the nature of equity, dealing with child support, something like that, they can do it. Meaning, if they want to create a statutory administrative court to adjudicate their divorces, and let's say they want to give it to the circuit court, they can do that. But you don't need statutes to litigate a divorce case or to invoke a court's jurisdiction, because all of the legislative authority and jurisdiction is dependent on the common law. Without the common law, it ain't no government. So you can let these people make fun of you and trick you all you want. Don't fall for their tricks, because they're lying to you. They lying. And the legislature has the unquestioned power to vest in inferior courts of statutory creation any of the powers or portions of the jurisdiction of the chancery, which is equity, or circuit courts, to be exercised concurrently with those courts, if the latter are not completely and constitutionally supplanted. Meaning if the Constitution didn't finish it, or they just didn't put it in the Constitution or something like that, then they'll authorize the legislature to do it. All right. Superior courts acting under statutes are quad hoc courts, aka inferior courts. Let me see if I got some more stuff down here. Yeah, I do got some more down here. Let me go back to the chat because I want to make sure y'all are getting this stuff. All right, make sure y'all hit that like button. If you want to, if you have any questions or anything like that, just press 1 and I'll turn your microphone on, and then we can go from there. All right, so let me I gotta read y'all some more of these cases because I want y'all to see that this is what they're doing. And this does not just apply in Alabama. These principles that I'm reading, y'all, this applies everywhere, y'all. Everywhere. It is familiar law that when statutory authority in derogation of the common law is conferred on courts of general jurisdiction, such a court of general jurisdiction becomes quad hoc a court of inferior or limited jurisdiction. Here are all the cases right here supporting that contention, all of them. The jurisdiction to grant divorces is purely statutory. What? And courts upon which jurisdiction is conferred in common law, are conferred in Alabama are quad hoc courts of statutory and limited jurisdiction. I know that's a fact because I've litigated divorce cases in Alabama before, and they are all under statutes. All of them. That does not mean that you can't petition for a divorce in equity without statutes in Alabama. You can do that. They're probably not going to tell you that. Accordingly, while the circuit court is ordinarily a court of general jurisdiction, in the particular proceeding now before us, it is made a court of limited jurisdiction by the statutes. What? Is this making sense for y'all? Because it makes sense to me. It is the settled rule that where a special authority in derogation of the common law is conferred by statute on a court of general jurisdiction, it becomes quad hoc an inferior or limited court. A compliance with the requisites of the statutes is necessary, is mandatory to its jurisdiction, and must appear on the face of its proceedings, of its administrative proceedings, upon its legislative proceedings, upon its limited proceedings. There go all the cases right there. This does not just apply in Alabama. This applies everywhere. I did it. If y'all gonna watch them videos that I just told y'all to watch not too long ago, I'm showing you in the videos other Supreme Court cases from different states holding this same principle. Let's go back to the chat. All right. Let's get, okay. All right. The Constitution empowers the legislature to establish two kinds of inferior courts. Article 6, Section 168 authorizes the establishment of inferior courts instead of, in lieu of means instead of, it's in Latin, of justices of the peace. And Article 6, Section 139 authorizes the establishment of other inferior courts. Look at this. Look at the other inferior court. What are you talking about? Can you substantiate that for me, please? What are y'all talking about? This is why I don't like dealing with these people. But this is why you have to read cases, because the cases are going to substantiate it for you. They're going to tell you what they're talking about, and they're going to limit. They're going to tell you the scope of their legislative authority, the limit of their authority. There is an excellent discussion of inferior courts and their distinctions in the case of ex parte grant. There go the case right there. I might go back and read it. I don't know. If y'all, I'll go and read it if y'all want me to read it, but I'm not going to read it on here. But if y'all want me to go and read it, I'll read it. All I have to do is click on it, and the case gonna pop right on up. In respect to inferior courts of statutory creation, it is within legislative competency to prescribe how and by whom the judge thereof shall be. Did y'all see that? In respect to inferior courts of statutory creation, it is within legislative competency to describe how and by whom the judge thereof shall be elected. The legislature has exclusive authority over that to prescribe how the so-called judges are going to be elected to these administrative courts, so-called courts anyway. They ain't courts. I don't care what they say. What is this? Petition to appear, judge, contempt, quash rule. I think this is it. Yeah, that was it on that. But let me go back because I want y'all to read. I want y'all to see something about these so-called uh, courts of the legislature. I wish I can make this bigger. I've read this plenty of times on my channel. I posted this probably a year ago, but I got to keep reading it because I want people to understand this stuff. Let me go back and check the chat right quick. All right. Jurisdiction. I might read some more of that. I don't know. What was I? Where was I at? Right here. Nope, it was this one. All right. Right here. So I'm gonna read this case citation for y'all. Let me give y'all the case citation right quick. All right, this is the case citation. You can read it and go and find it at. This was decided in 1947. It's an Alabama Supreme Court case. But the case citation that I'm going to read you is older than the one than 1947. So where are we at? All right. Pay attention, y'all. It says the system is in itself and of itself complete. And though there has been a grant, a permission, or privilege, or reservation to the General Assembly, which is the legislature, of power to establish inferior courts, aka administrative agencies, of law and equity, there has not been any part or any fraction or fragment of judicial power left in abeyance, meaning that we ain't no judicial authority left over for you to do this. Ain't none. Even though you have the authority to create inferior so-called courts. You have no judicial authority. I got to read that again, y'all. I got to read it again. This does not just apply in Alabama. The legislature does not have any judicial authority. So, in a sense, you can argue that, let's go to Google. Chrome, none, I probably spelled it wrong. Judice, quorum none, I probably spelled it wrong. Right here. So, in a sense, you can argue, and I think that this argument would have merit. Let's go down. I'm gonna get the legal definition. Is it gonna pull up? Probably not. Nope, not gonna pull up. All right. So you can argue this that before a court lacking the authority to hear and decide the case in court, since they don't have judicial authority, because they don't have judicial authority. Quorum non judice, Latin for not before a judge, is a legal term typically used to indicate a legal proceeding that is outside the presence of a judge or in the presence of a person who is not a judge, within proper venue or without jurisdiction. Now, they do have jurisdiction. However, I'm of the opinion that they typically, generally speaking, they don't have jurisdiction to adjudicate private rights. When you go to these administrative hearings, typically what they are going to 9 times out of 10, they are going to rule in favor of the public right. They're going to adjudicate the case in favor of the public, meaning the government. That's what they're going to do. That's what they're going to do. And a lot of people don't know who they're dealing with when they go to these administrative courts, man. A lot of them don't know. Check this chat. All right, let's get, where we at? Right here. All right. So let's go back again. Where did I stop at? Let's see. Though there has been a grant or reservation to the General Assembly of power to establish inferior courts of law and equity, there has not been any part or any fraction or fragment of judicial power left in abeyance, awaiting the happening of any future event or the exercise of future legislative power to vitalize or quicken into activity. If the General Assembly never exercised the power to establish inferior courts with which it was clothed, and its exercise is purely matter of legislative discretion, the whole element of sovereignty known as judicial power would exist, confined to tribunals which may properly be said to be of constitutional creation. They don't have any judicial authority. None. None. They don't have any. So if they don't have any, what authority are they exercising? What are they doing if they don't have any? You are in an administrative agency that is authorized by the legislature to do something. It's an administrative hearing before an administrative officer. Administrative agencies, which are courts of so-called courts of limited jurisdiction, like all U.S. district courts, those are executive administrators in there. I don't care if they say United States District. I don't care I don't care if they call it a court. It's not a court. I don't care about that. It's not a court. It's not a court. So courts of general jurisdiction, their jurisdiction is broad. The reason why their jurisdiction is broad is because they were given their jurisdiction by the sovereign via the Constitution, the sovereign being the people of each so-called state. They were given the authority to do what they're going to do by the sovereign. And the sovereign said, okay, you get judicial authority, you get legislative authority, you get executive authority. But even though we're going to give y'all this authority, it's really a privilege. We can take it back whenever we want. Because the ultimate judicial authority, executive authority, and legislative authority belongs to us. Essentially, that's what it's saying. Where is that? You know what? Let me. I gotta pull up one more case for y'all because I gotta get y'all to see this, man. I gotta get y'all to see it. Let me see if I can pull it up. Give me a second. I'm on my other computer right now. Let me see if I can pull this up. Let's see. Michael versus State. Let me 40. I think this is it. And I might have to go. I did a video on this not too long ago. I might have to go back and pull it up on another website because I don't think it's going to be on here. So what is it? It is volume 40. Let me see if I can find it, y'all. Probably ain't going to be on here. So it's volume 40, Alabama Supreme Court, 361. Probably not going to be on here. It ain't going to be on here. All right, so I got to go to another website. Let me go. What is this? What is this? I got to go here. I got to find it on here. I know it's going to be on here. All right, right here. It's going to be on volume 40, right here. Page 361, Michael versus State. There it is right there. All right. I think it's going to be on page 9. Let me see. It should be on page 9. And I'm just going to read y'all a principle. Now, this case, if I'm not mistaken, this case was decided before Alabama was a part of the United States. This is a good case, too, by the way, y'all. This is a real good case. Let's go to, is it 12? I think it's 12. Or it's 9 or 12? Yeah, right here. Let's make this a little bigger. When I say the ultimate sovereignty or whatever, so I gotta make this a little bigger. Let me go back to the chat. I gotta keep monitoring the chat from time to time. All right. Let me check the phone lines. All right, cool. All right, if you want to call in and press one. But let me read y'all something. Let's get back to where is it? Michael versus. Okay, it's not on here. So let me delete that. Where is it at? Right here. All right. So I'm gonna point out something to y'all. All right. It says no doubt the ultimate sovereignty, the government making sovereignty, meaning the power to create government, resides in the people. All right. So if you're the ultimate sovereign, and you have the ultimate sovereign power to create a government, what makes you think that you don't have the ultimate sovereign power to nullify at will every Supreme Court decision that you don't like? Because you can, because the Constitution can't stop you from doing it, because it doesn't apply to you. But anyway, no doubt the ultimate sovereignty, the government making sovereignty, resides in the people. But this is why you need to go and read old cases. After a government is once formed by the people, they can only exercise this sovereignty. What sovereignty they mean? The power to create another government. That's what they're talking about. They can only exercise this sovereignty, meaning the power to create another government, by revolution or in the manner they have prescribed to themselves in the Constitution. The state, pay attention, y'all, in its corporate capacity is the people, but you don't know your rights. Your public servants are acting as if they are you, and they're taking advantage of you because you don't know your rights. So let me reword this in another way. You're not dealing with the so-called state in its sovereign capacity. In my opinion, I don't. When I use the word state, I mean people. That's what I mean, because the state has a dual capacity. The people are sovereign, and then the corporation that represents the people, that, okay. But you're dealing with the state in its corporate capacity. That's who you're dealing with. They're filing lawsuits against people. And it's in a court of not general, it's in a court of limited jurisdiction. It might have been a court of general jurisdiction, but they're filing so-called criminal charges against you under statutes. They're pulling you over, issuing you traffic citations under statutes. Police officers exist under statutes, not common law. It's not the sheriff. All right. Generally speaking, all of this stuff is under a statute. When they sentence you to jail, they doing it under a statute. When you file an appeal, you're doing it under a statute. When you invoke their original jurisdiction, you're doing it under a statute. When you invoke their appellate jurisdiction, you're doing it under a statute. When you go to the DMV and they say you got to have this, this, and this to get a driver's license, whatever, everything they're doing is under a statute. Everything they're doing is under a statute. It's all the same thing, man. But you don't need statutes to invoke appellate, original, or supervisory jurisdiction. You don't need that. They're not going to tell you this, but you don't need it, because you can invoke their jurisdiction under the exclusive jurisdiction of common law of equity. You can do that. I know how to do it. Let me go back and check these lines, man. How you doing, one wise lady? What is revolution technically? Does it have to involve war by definition? What else you think it is? what, what? But I understand why you're asking that. And that's a good question, SG, because you know when you're reading these cases, you got to be, hey man, you got to see what these folks talking about. But this case, SG, they were actually having a revolution. They were going to war in this case that I got this case citation from. They were actually going to war in this case. What I'm gonna do is I'm gonna read over this case again because I haven't read it in a long time. I'm gonna read over it again, and then I'll do a video on it for y'all. But these people, this is before Alabama became a part of the Union of the United States, or whatever. They were really going to war. This was a good case, really good case. What this is, if I'm not mistaken, this case is going to implicitly, not expressly, but implicitly discuss the doctrine of title by conquest, meaning legal title ownership to land by conquest, by going to war. That's what they're gonna talk about. Let me go back to the chat right quick. Essentially, yeah. Essentially, yeah. Let me see. He got a Arnold. In the case of Arnold v. State, he got there's a principle in the Georgia Constitution. Basically, it says, when the government they relieve you of the duty of obedience to them if they don't hold up their end of the deal. I have to go back and read. I don't know what it says verbatim, but it says something to that effect. That's equity, though. I mean, how you gonna hold me to a contract that you're not holding yourself to? When we made this contract, we were on equal footing. We were both in mutual agreement of what was to be expected of each party. And now you're reneging, but you still want to hold me to my end of the contract. But you don't want to hold. You don't get the hell out of my face. Hold on, man. I'll be right back here. I need some water. Uh, Got it. Yep. Social contract, which is a contract, by the way. It is a contract. All right. Let me go and check the lines again. All right, cool. Okay. Let me see if there's. I'm trying to think if there's anything that I'm missing. So, all right, y'all. Are y'all okay on a scale of 1 to 10? How good are y'all understanding superior courts versus um inferior courts after this video? Because I want to make sure that y'all understand this. To me, the word civil is synonymous for contract. You might be right. You might be right, SG. I don't know. Let's see here. I want to find some more cases on this because I want y'all to see that this is a principle. I think this is one right here. Let me see. Yeah, here go one right here. I think let me go and read this one. I think this is gonna be a pretty good one right here. I'm gonna read the case out. I'm only gonna read the principle, y'all. I'm not gonna read this whole case because I be wanting y'all to see these principles. And I'm gonna go back when I get some time. I'm gonna find out how old this principle is. Let's see. Let's go down. Matter of fact, let's just do it this way. There it is, right there. All right, so here go that principle again, y'all. Let me see. Hold on. The proceedings had before the Superior Court leading up to the order referred to, which were supplemental to execution, were by the terms of the statute itself, suffer special in their nature. unless ram blah 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 being revoked, which was not the case in the proceedings now under blah blah blah. Okay. So here it is right here. The rule, and this is a Washington, if I'm not mistaken, this is a Washington case, state of Washington. The rule is stated in the following standard text: where a court of general jurisdiction proceeds in the exercise of special powers wholly derived from statute and not exercised according to the course of the common law, or not pertaining to its general jurisdiction, its jurisdiction must appear on the record and cannot be presumed in a collateral proceeding, although the court proceeds in accordance with the course of the common law as far as applicable to the proceedings. It is an established rule that when a court of general jurisdiction has special and statutory powers conferred upon it, which are wholly derived from statute and not exercised according to the course of the common law, or on the record, and cannot be presumed. Cannot be presumed. It is well settled that a judgment in a summary proceeding must show upon its face everything that is necessary to sustain the jurisdiction of the court rendering. Now, I'm not sure if y'all remember, but I posted something a while back. I was doing some litigation in a so-called family court, and the judge, the so-called judge, he said he ordered visitation, or I don't know what he said. He said he ordered something, and I asked him a question. I said, "You ordered custody or visitation?" He says, "Yeah." He said, "Yeah," and I said, "Under what statutory authority did you do that? This is a legislative court." And he said, "Oh, well, we're not going to discuss that." I know the hell we ain't, because you lying. This is a legislative court. You need to state the basis of your jurisdiction on the face of these administrative proceedings. You can't trick me, homeboy. I did my research. You can't get me. Let's see. Now, I also want y'all to pay attention to this too. When they say just because it's a court of record does not mean it's under it's acting under the jurisdiction of the common law, because I told y'all earlier what they're trying to do is they're trying their damnedest, and they're getting away with it too. They've been pulling it off for a while. They're trying to make their administrative inferior so-called courts look and function just like our courts. Their courts adjudicate public rights. Our courts adjudicate private rights. You don't have any public rights. You have private rights. So how did you get into these patently administrative proceedings? How are they exercising? They're not going to tell y'all this stuff, man. They need your consent to have jurisdiction over you. Or they have to have service of process has to be perfected in a manner that is consistent with due process or your consent. Those are the only two ways that they get jurisdiction over you. That's it. They don't get jurisdiction over you in any other way. That is it. I've read that in cases. I did a video on it telling you that it expressly says that they need your consent, or they need to afford you service of process. They need to perfect service of process against you to have jurisdiction over you or your consent. That is it. Let's see. Uh, Put simply, if a statute does not apply to your issue, it's going to superior court, if not barred by jurisdiction issues. I'm a little. What do you mean, SG? I'm a little confused. Yes, a little. Y'all make sure y'all hit that like button for me. I really appreciate that. I think I can close this on out right now. Right here. All right. The jurisdiction exercised by courts of record is, in many cases, dependent upon special statutes conferring an authority in derogation of the common law, and specifying the manner in which such authority shall be employed. The described, the decided preponderance of adjudged cases upon the subject establishes the rule that judgments arising from the exercise of this jurisdiction are to be regarded in no other light, and supported by no other presumptions than judgments pronounced in courts not of record. The particular state of facts necessary to confer jurisdiction will not be presumed, and if such facts do not appear, the judgment will be treated as void. The Supreme Court of the United States has laid down the rule that when a statute prescribes the manner in which the rights conferred by it are to be pursued, and the powers delegated by it are to be exercised in a special and summary manner, the proceedings of the court will be considered as the same character as the proceedings of courts not of record. When they say courts not of record, they mean it's administrative courts. They mean inferior courts. They mean, yeah, administrative courts is what I'm trying to say. But when the statute confers new powers and rights to be brought into action by the usual form of common law or chance, notice, did y'all just see that? But when the statute confers new powers and rights to be brought into action by the usual form of common law or of chancery practice, the proceedings and judgments of the court will have all the characteristics of the proceedings and judgments of courts of records. Did y'all see? I told y'all that's exactly what they're trying to make their courts look like ours, y'all. And that's what they're doing. I don't care if the juvenile court or child support, I don't care if they have a court reporter in there. They acting under a statute, not a statute, not a statute, a statute. I'm sorry. That's what they doing. That's what they doing, man. That is how you distinguish courts of general jurisdiction from courts of limited jurisdiction. Courts of general jurisdiction, their jurisdiction is broad. They can do anything without a statute. Courts of limited jurisdiction is extremely limited. They cannot do anything without a statute, just like an administrative agency can. That's why they say so-called inferior courts are akin to administrative agencies, because that is exactly what they are. They can't be called judges because of separation of powers. But anyway, they can call them judges all they want. Let me show y'all something. Let me show y'all something, man. Because they get y'all with it. They don't get me. They don't get me at all. Let's just pick out a random. Let's go to the Fourth Circuit. Hold on, let me go back. That principle, what I just read in that Washington case, applies everywhere, not just in Alabama, not just Washington or just Montana. It is an established rule that when a court of general jurisdiction has special and statutory powers conferred upon it, which are wholly derived from statute and not exercised according to the course of common law or not a part of its general jurisdiction, it is to be regarded as quad hoc and inferior or limited court, and its judgment, blah, blah, it's the same thing. Here it is in Oakland, right here. Right here in Oklahoma, same thing in 1926. So on and so on. 1930, Idaho. All right, but let's go to the here's one in Texas too, then I go to one. A court of general jurisdiction has powers conferred upon it by statute, which it does not otherwise possess. It is to be treated as a special tribunal. This is a special court. It's special. Anyway, let's go to the federal. We're gonna go on the federal level right now. That's where we at. We're gonna go. Let's see what we got. Okay, we're gonna go to the Fourth Circuit, just randomly Fourth Circuit. We'll say district court or courts of limited jurisdiction. I got to show this to y'all, man. That one right there. We begin with the under guiding principle that federal courts, unlike most state courts, are courts of limited jurisdiction, created by Congress. Is not Congress a legislative body with specified jurisdictional requirements and limitations? All right, I just got to show y'all this. District courts are courts of limited jurisdiction. These are federal cases too, by the way. They possess only that power authorized by the Constitution and statute. Now, I don't know any authority that they have under the Constitution that I could be wrong. I don't know any, but I don't study that, so that's why I can't say I don't know any. You know, what I mean, that's why I can't say I know any because I don't really study that. But I do know that they are created by Congress. Subject matter jurisdiction generally, federal district courts are courts of limited jurisdiction. Federal district courts are courts of limited jurisdiction. Federal district courts are courts of limited jurisdiction. Now let's go to the appeal courts. The federal appellate courts are courts of limited jurisdiction. They were created by Congress. This is the statute right here that you use to appeal to the U.S. Court of Appeals for the Fourth Circuit, the Fifth Circuit, the Sixth Circuit, the 11th Circuit, the 12th Circuit, if there is a 12th Circuit, the first, second, third. All this is the statute that you use. Who is that? Give me a second. I'll be right back. That's the statute that you use to appeal to the appellate court. Now, let me show you the statute that you use to appeal to the U.S. Supreme Court. I don't care if they call it a U.S. Supreme Court, because anytime a court of general jurisdiction, which is the U.S. United States Supreme Court for the United States of America, is a court of general jurisdiction. All right, but once it starts exercising jurisdiction under a statute, it is no longer a court of general jurisdiction. It's two of them, y'all. It's one created by Congress and it's one created by the Constitution. And they doing this everywhere. Y'all make sure y'all hit that like button for me. Okay, apparently chancery and common law are different. I thought they were the same. Chancery appears to be equity. Yeah, that's right, SG. Man, I ain't gonna lie, common law brutal. Equity is too, but uh I think equity is where it's at. There's a saying that God judges in equity, and I think equity is where it's at. Equity deals with what is just, what is fair, and uh, and right under all of the facts and circumstances that are considered before the chancellor. So I agree with equity. You know what I'm saying? I agree with it to the extent that it's applied um, in a manner that it's supposed to be applied. Let's see. All right, so y'all hit that like button for me if y'all don't mind. Is this helping y'all, man? Understanding the distinction between general and limited jurisdiction. Let me see what this is. I got all these people that text me. What is this? All right. Let me find the so-called Supreme Court of the United States. I gotta find that statute for their appellate jurisdiction. Um, put something in like this. We have appellate jurisdiction pursuant to, watch it just, I probably got to go to the United States Supreme Court. The district court had jurisdiction pursuant to blah, 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 and we have appellate jurisdiction, okay, blah, blah, blah. So let's go to the U.S. Supreme Court. Notice they say U.S. Supreme Court. They marking all their territories. The U.S. Postal Service, the United States Department of Transportation, the United States Border Patrol. They marking all of their territories. We thus have direct appellate jurisdiction under 28 United States Code 1252. I'm not sure that, I mean, this statute might have changed. This case is a little old. We have jurisdiction to review this decision below. Okay, so this might be a common law um thing right here. Ain't no statutes in common law, y'all. None. So let's say if you litigating a case under the exclusive jurisdiction of common law, but you believe that this judgment is void, it should be vacated. You can either go to equity. It's really just going to depend on where you at. You can either go to equity, or you can petition for maybe a writ of mandamus or a writ of certiorari, because at common law, if I'm not mistaken, appeals were taken in the nature of writs under the court's supervisory authority, because they have supervisory authority over inferior tribunals. Here's another one. Our appellate jurisdiction is based on blah, blah, blah. I just told y'all, whenever they start exercising jurisdiction under statute, it's no longer a court of general jurisdiction. You're in an administrative agency, inferior court. That's what they're doing. That's the distinction between courts of general jurisdiction and limited jurisdiction. General jurisdiction here are all cases at law, in admiralty, in equity, and maritime. So-called courts of limited jurisdiction, they can only they can only act within the manner prescribed by statute. That's it. And their jurisdiction is not presumed. They're not entitled to that presumption. That tells you that also tells you right there that the legislature is not sovereign. Is common law biblical? I do believe. I think common law and equity are God's laws. I just think equity is, it's more vast. There are more remedies for injuries in equity as opposed to common law. Like equity punishes you for just doing inequitable acts that you may not be able to um to litigate under common law. You may not be able to, to litigate something like something inequitable under common law. Even if they well, I don't want to say that because I don't want to confuse y'all. All right. All right. So Let me check the phone lines. I don't know how much time we got. Damn, somebody got the hand. I'm sorry. All right, caller 8588. Good evening. How you doing? You live? You on the air? What's going on?
That's Gary.
What's good, Gary? How you doing, man?
Um, what you what you were saying is absolutely right about their jurisdiction. They have procedural and process. As long as they're giving it to you, they consider that a constitutional court. But it's not, because everything they do is hearsay, a presumption, unless you rebut it. So how many people rebut it? How many how many lawyers go in with their clients and rebut it? They don't. So it becomes what you said.
What do you mean everything is a presumption? I'm sorry to cut you off, but I'm trying to understand what you're saying.
Well, for instance, when you get an order of protection and there's no judge, there was no police called, and there was no prosecutor. Okay, so she goes into court, said, "He hit me." Presumption. So you have to come back now, and when she says you hit her, that becomes a presumption. They hear that. But in the long run, she has to have the 4 elements to meet that presumption, which they don't do, because it has to be done with the prosecution, it has to be done with the jury, and it has to be done with a real judge, a constitutional judge. I sat in on a case, my friend's son's case, a criminal court, a constitutional criminal court. The judge already set him his constitutional right from the beginning. You don't get that in family court.
What did you say? You said
you don't get that in family court.
The judge already did what?
Set his constitutional rights. In other words, he has the right to a fair trial, to have his evidence and stuff like that. So what they did was they presumed he was crazy, okay, incompetent. So it was an incompetent hearing, okay. They found that he was incompetent. At that time, when they found him incompetent, they were supposed to put him under arrest and bring him to an asylum to get medical treatment, to see if they could bring him. They said to see if he could be brought back into society. Well, he's so far gone, he could never be back in society. So what they did was they released him, and hoping that he will fuck up again. Excuse my language. So they could get him on menace of society. In my case, remember I told you my kids are in Hawaii. They said Hawaii is part of the United States. I said, no, the hell it ain't. Because it has statehood, but it's not connected within the borders. We had a border argument. Okay, I won that case. Okay, I won that case. But technically, I won it in my eyes, but they say, oh, no, the United States, Hawaii is not part of the United States. No, they're Pacific Islands. They're part of the Pacific Islands. They're not part of the United States. You can't. You have to be connected. So what they did was, without my ex-wife going into court and saying, I don't want to leave Hawaii. I don't want him to take my kids out of Hawaii, okay, and have a hearing on that. They just put it in the document. So the judge was that I couldn't leave Hawaii. And I said, whoa, wait a minute. What's the state interest in this? Did I injure the kids? Did I ever not bring the kids back? How could they do it? They were just exercising her authority. They're just being a lawyer for her.
Yeah, well, you have just as much to say so over, your kid just as she does.
Yeah, I know that.
Let me backtrack just a little bit here.
I told them.
Let me back because
I told them what.
I got to say this. I'm sorry to cut you off, but I have to say this because I have other people listening. I don't know how they do it where you are, but when I litigate cases,
I'm in Iowa.
Okay. When I litigate cases in juvenile court or Alabama, whatever, this is how it typically goes. Even though it's an administrative hearing and it looks like a court and it's functioning like a court, this is how it typically goes. You make a claim, then you go through some sort of not due process, some sort of discovery to get proof of your claim. So you might have some sort of evidentiary hearing where all of the witnesses will come in, they'll testify under oath, there'll be a court reporter in, you get to cross-examine on direct, stuff like that, and then the so-called judge will make a ruling based on that particular evidence. That's how it works here. Let me rephrase
That's
that.
the way it's supposed to work.
Let me rephrase that. That's how it's supposed to work. Because I am of the opinion that everybody, and I'm just speaking for people who are pro se, they don't get that type of due process, because that's essentially what it is. It's a due process. They don't get that type of
Right.
due process because these people are just corrupt, and you're already going in here, you're ignorant, and you don't know what's going on. They telling you to shut up, you can't talk, all this. They're just running all over you. You know what I'm saying? You don't know what's going on.
Right.
You don't know. There may be some paperwork that's material that is going to determine the outcome of your case that you should have gotten, and they don't even give it to you. You don't know it until you probably not find out about it until about a year later or 6 months later or something like that. So people just gotta read and do their research. Do not, if you can't afford an attorney, you're gonna have to do this on your own. Because there's some stuff attorneys are just not going to go in there and argue. If it's anything that is valid and it's against the status quo, I don't care if they don't care if it's valid. If it's going against the status quo, then I'm about 95, somewhere 98, 99% sure that they're not gonna go in there and argue that for you. I think these people
No,
will
they're not.
these people will get. I'm of the opinion that these people will get sanctioned and probably disbarred if they go in there and try to argue some of this stuff.
I wrote an article. It's on Facebook on a lawyer's firm. I wrote everything about family court, and he came out and said, "You're pretty well versed with the constitutional law and family court." So blah blah blah. Down at the end, I said, I bet all the lawyers will not tell their client that it's not a law, child support. It's a program. And I said, if you were to go into court and argue that issue, it's a program, they would sanction you and disbar you for even trying to ruin the government making money. Because it's a program just to get money. That's all it is, a recoupment. So, I won a case today in child support hearing. I coached this guy for a week.
You won one?
Yeah, in Davenport. Yeah, he won his case.
Good job. Good job.
His wife and him went down. They told him his wife could not speak in court. She said, "Yes, I am, because this affects me, my income too. Because you're gonna attach more money to him because he's gonna benefit off of me. So you're gonna say he's benefiting off of me. So I have a right to say something."
Yeah.
And that's what I told her to say. And I coached them what to say, what not to say. So they wound up throwing it out of court, a paternity case out of court.
Okay.
Because they knew what they were talking about.
That's good, man.
They knew what they were talking about. But hey, I know you said you got to go. I'm waiting on your phone call. Give yourself about an hour and a half, and I'll send you shit. We'll talk about everything. But everything in family court is a presumption and procedures. That's it. It's bullshit.
I'm of the opinion that like they're just trying to make it look like it's an actual court, but it's not. Like
I always
go ahead.
I always go after their writing, like they say in family court. And a lot of guys, you'll see that in your paperwork. We base child support and custody on the parent that will facilitate the relationship. Okay? That's how I attack it. Because the mother's not giving you visitation, she's denying you. That's automatically grounds of not paying child support, according to that statement that you read on, I think, the Rose or Remedy, whatever, which one? Okay? The one that you were reading a couple weeks ago. Huh?
What do you mean by that?
Well, remember you were reading the one that if the mother blocks the father from seeing the children, he doesn't have to pay child support. Remember
Yeah,
that?
yeah, okay, yeah, yeah.
Well, that's exactly what. So how is she facilitating the relationship? She
Okay,
ain't.
okay.
So I dug into it. Look, I dug into it a little more. Facilitate, okay, is like aiding and abetting in a way, okay. But they say maybe they may be facilitating. The best parent who will who might, if they put might behind it, it's not guaranteed. If they put the word must, then that is what has to be done. So you have to look at every word. You have to syntax every word.
Okay.
May, must, shall. All those words in your document is in there for a reason.
Mm-hmm.
So when she goes to court and says, well, it says shall, or might, or may, it's all a presumption that she's going to do it.
Okay. I think I kind of get what you're saying, but you're saying that it's in the order. You're saying that the terms that they're using in the order, um,
Yeah.
they're I don't know how to word it in a way without
Legalese.
not
What they're
legalese.
doing is
Yeah,
using
I think I
legalese.
get what you're saying. I think I get what you're saying.
One of the documents I sent to you states it from the Supreme Court. They shall not use may and must or shall. No, they should not. They can't use may and might. They have to use a definite word like shall. You know
Oh,
that
so you're
means
saying
you're going to have to do it.
you're saying that there's a court there's a case law established on telling them the language that they must use in dispositions in resolving family court.
Yeah, that's one of them I gave you. It's from the Supreme Court.
Okay, that's interesting. I didn't know that.
Yeah, if they use legalese in syntax language that you can syntax, like order. Okay, well, you order me what? What do you want me to order? You want me to order pizza? You want me to order Burger King? What?
Yeah.
Or how about go outside? Outside where? Where does she want me to go outside? Where? All this
So
is all syntax.
so you're saying that they need to be clear. The order needs to be clear and succinct.
Clear,
No ambiguous.
clear
No
for
no
both
ambiguity.
parents.
Yeah.
Right.
Okay.
Which is never done because his lawyer is not going to do anything for him. I've not met one lawyer yet that will do anything for his client when it comes to family court or child support. Because family court is based on how much money they're going to get off the father.
These well
Visitation, okay?
they seem to be not. Don't get me wrong. I think that there are more bad attorneys than there are good ones. That's just my own personal opinion.
Uh,
That's my own personal opinion. But the good ones, they really will, boy. They'll go to bat for you, man. They're not gonna go in there and argue some of this stuff that we talking about on here. But outside of that, they will go to bat for their clients.
yeah, as long as it doesn't impede on their government making $60 billion a year off of
I agree
child
with that.
support.
I definitely agree with that. I agree with that.
They
That's
can
why I
fight
said you
anything
don't
they
have to
want.
argue any of this stuff that we making. Um, these arguments that
So,
we're making.
so my argument is going to be this: how can I be found guilty of my constitutional right of not travel from Hawaii to the United States without a hearing, without a proper hearing? Well, this is how they did it. Her attorney wrote a letter, okay?
Mm-hmm.
Put a tracking number on it, okay? Just a tracking number. Say it was delivered, okay? I never got it. So he submitted it to the court, and And he said, well, the court, he never opposed it. So, let's, move on this, him not leaving Hawaii.
Yeah, so it was
Well,
that's a
now I get,
presumption. Service of process is a presumption.
right. So what I did was did a knock pro tunk. From here in the future, I will not accept letters that have not been stamped by the court and certified properly of due process. It keeps them from doing what judges do, write orders in favor of mothers. That means I have to have a hearing on any matter that he's trying to bring me in,
You was supposed to have a
and I
hearing
give it
on
to the
that.
court.
They must have like he must have sent it certified and got a tracking number for it and filed that in the court and
No,
used that tracking number as a basis for getting his motion granted off a presumption that you received the letter.
yeah, it's just a basic stamp on the back of the letter has all those numbers on it. It's not a green one. It's just saying that the post office delivered it.
Yeah, that's just a presumption though. That's
You're right.
just
So I wrote in there. I wrote a document out
just because
that
go ahead. I'm sorry.
that I will not accept any letters that have not been time stamped and an order behind it saying they filed a motion to hear, okay, a claim why I can't leave Hawaii with my children. So what they actually did was a ex parte. They ex parte between themselves without me.
Yeah, that's a due process violation.
Right. So that's what they ex parteed and did this thing without me knowing it. So we go to court, and it's never brought up that I received a letter. So when the judge did his order, he wrote in I couldn't leave Hawaii. Well, where's the fucking injury? Why? Just because the mother? I thought you said 6 years ago the mother has the right to travel, and I have the right to travel. Now you're stating constitutional law in family court. You're granting constitutional issues.
If they issued that order, decree, judgment, whatever you want to call it, if it was issued, and I'm of the opinion based off what you're saying, if they issued it in a manner that is inconsistent with due process, it's patently void. Like it's
right.
void. But you're gonna have to go in. You're probably gonna have to rule 60B4 or whatever. I don't know what the rule is in Iowa, but it's gonna be very similar. The substance of the rule, which is really a principle for real. That's really all it is. They just made it into a rule. But you're gonna have to go in, file a motion to vacate for lack of in personam jurisdiction due to imperfected service of process, something like that. Which is that's what I did in my case. That's what I did in my case.
And another thing was the COVID that barred me from having a hearing because you don't want to have a telephonic hearing. You never want to do that. You don't want to do a Zoom. You always want to have, under the Sixth Amendment, you want to see your people who is accusing you.
Mm-hmm.
So I lost 2 years on that. So I got to write an argument about the government restricting our movements from Hawaii to here and all this other crap. But I come to the conclusion that family court and child support is all presumptions and procedural process, due process. They have to give you the service. They have to give you the proper things. But other than that, they can do whatever they want. And in my cases, it shows that they're doing what they want.
Yeah, to a degree, they seem like it, you know what I'm saying? But to be honest with you, I'm of the opinion that they don't really have to give you any type of process, unless it's authorized by statute because they're administrative agencies. They just do what they do. But
they can't say that you can't move, you can't take your kids out of Hawaii if there was no injury. What injury was there?
I agree with that. I agree with that. And then that's a private right that they're infringing on too, by the way, which is the right to travel,
Yeah,
the right to interstate travel, not intrastate
right.
travel,
With this,
because you do have a right to intrastate travel. I don't know why these people were coming in. They came on my video talking about the right to travel only extends for you to travel from one state to another. You got to be stupid if that's what you believe, or you just got to be ignorant and you just don't know what you're talking about because they're lying to you.
well, the Constitution, you have the right to go from state to state unchallenged. But when you leave the country, like my wife had to get passports for the kids to go to Hawaii, even though it was part of the United States, because they're crossing over international waters. They had to get passports, and I was arguing that too.
Yeah.
International waters. She left the country. One moment she left the country, crossed into international waters, she's no longer in the country.
No, she ain't. She's outside of the territorial jurisdiction.
And the feds agreed with me on that. I got a hearing. I mean, I got a thing in the federal going down to the FBI and sitting and filing, like I told you, my complaint about slavery, child support as slavery. So they want to listen to me.
Like I did a consultation for a guy
90 seconds.
on Zoom. It was a video consultation, and he was asking me he just had some questions about the child support because he's trying to get it vacated. But the guy who wrote that ebook, y'all, he posted. I mean, not posted, but he wrote like the arguments that you need to make. They're in that ebook.
60 seconds.
They're in that
Now,
ebook.
the very first child support order came out not through the legislation. It came out from the executive branch under 7710, HR 7710 back in 1975, August. Look it up. It's 95 pages long. That is the first child support order. But people kind of believe it's not. It is. It specifically says it. It's a program.
To be honest with you, it sounds just like a program. It acts just like a program. I don't see how what I'm trying to figure out is how are they well they're acting under some sort of statutes.
10 seconds. Yeah, the statute that they're using is collection. It's obligation rights. When the mother signs over her rights, the child support agent becomes a third party obligation under that law. Third party. You can also read that because of the doctrine of what's that doctrine about the orphan doctrine. They even state that. They even stated in there they use the children to refund their money. And child support, they're using watch movements, parts. Now, how the fuck excuse my language, how does parts for watches have anything to do with child support? When you read it, you'll understand. It's nothing but a program where they got the 33%, 75%, 63%. That is the collection agency. It's only for collection. That's it. There's no law, because I even had the document when the governor of the state says we have no authority to implement child support because of our Constitution. So the United States government gives them a certificate. We talked about it last couple of weeks ago. They gave them a certificate, a partnership. I've got all that shit. I even showed the guy. I said, see, it's nothing but a program. It's no law. When they say law, it's procedures.
I was looking at the chat right now. and Rogue Nation said something. Rogue Nation, I'm I've read what you're talking about too. When you said it says the state owns the kids under parents' betrayal doctrine or something like that. I've read that before. They seem to act like they do, to be honest with y'all, but they don't.
Well,
I'm pretty sure
the marriage.
if they got on TV and started saying that they owned your kids, all hell would break loose, and there would be people dragging politicians out of their offices by their throats. Cause ain't nobody going for it. You don't own mine. They don't own mine. But I do understand what you're saying, Rogue Nation. As a matter of fact, there is a let me show you what I'm talking about. Let me go ahead and get off the phone, Gary. I'm sorry, man. Let me go ahead and get off the phone. But thank you for calling in, man.
Hey, go ahead.
When I get some time, I will call you. Okay.
All right.
All right. Thank you, man. All right.
Yep.
Let's get back to the screen sharing. Screen. Yeah. Where is it at? It's gonna be on over here. Give me a second, y'all. Alright. Alright. I posted this a while back. Give me a second, y'all. Somebody calling me. Give me a sec. I'll be right back, y'all. Let's go right here. Alright. Sorry about that, y'all. Let's get back to it. Let's go down. If y'all just scroll down through my through here on this channel, on the community section of my channel, I always post stuff on here. There's a lot of good information on here. I do a lot of research. Excuse me. Let's go down. Is that it? I don't think that's it. I think it's coming up somewhere. Let me see. I think that's an older case. That was a good case too, right there though. That was a good case. They were talking about this stuff almost over 100 years ago. How old is this case? Look at this. This is a Rhode Island Supreme Court case, and they were talking about um just taking the father from the kid. I'm gonna read this to y'all right quick. Read this to y'all. Well, I'm not gonna read it. I'm not gonna read it. Yeah, I'm gonna let y'all read it. Y'all can pause the video or whatever, and y'all can read it. But I want to go back to something what Rogue was talking about. I'm trying to find it. I posted a link to it and everything. Yeah, here it is right here, Rogue. All right, Rogue, if you're watching, here it is right here. And these are all of the authorities right here. The state, as parents' betrayal, has the original right to the control and disposition of all minors. It confides a part of its right to a parent as a trust. Like every other trust, when abused, it is forfeited and the state reassumes its original powers. And these are the authorities right here. And I posted a link to it. You can go and read this link because I did. It actually says that. This is the book right here. I Googled the book. This is the book right here. Which page is it on? Let me see which page is it on. All right, this is the book right here. It's on page 510 and page 158. Blah, blah, blah. So let's see, 510. Don't they have like a, right here, yeah, 510. Let's go to 158 right here. Let's see, infant, individual, superintendent of bringing education. guardian's duty will supersede them from their office and take away the infants from their care and custody. Yeah, right. See, but they're talking about they're talking about this sense in equity. They're saying it that it's a trust that they're giving you these kids like the kids belong to them. Man, you crazy? You out of your mind if you think my biological property belongs to you. You crazy if you think that. You gonna just that's just dangerous. Don't do that. Especially with me. Don't do that. Don't do that with me. I'm peaceful, but I'm violent when necessary. You know, I'm always protect myself if necessary, but I'm not inherently violent unless I have to be. And it's only in the sense of me defending something that belongs to me. uh um which page is this? I don't know which page it is, but anyway, we have. Can I make this bigger? Damn it, I can't make it bigger. How do I make it bigger? I don't know how to make it bigger. Oh, here it is, right here. All right. We have already had occasion to see that the courts of chancery, these are equity courts, as well as courts of law, common law, look upon the guardian, the parent. We're gonna replace the word guardian with parent. All right, because I want y'all to see what they talking about. This is how these people think, y'all. Upon the parent as the person who, under ordinary circumstances, is entitled to the exclusion of every other individual to the possession of the person of the infant, and the superintendence of his upbringing, of his bringing up and education, and that equity will enforce this right upon the parent on his complaint against all the world and even against the infant himself if he disputes. But as we have already found, equity requires also that the parent, de jure or de facto, and in general, all persons who have the care of the infants and the direction of their education shall fulfill their duties which the office casts upon them in a proper manner for their benefit. And as we have now to consider, the Court of Chancery for this purpose exercises a controlling power of all kinds of parents of the most absolute description, will compel the performance of their duties, will supersede them from their office, and take away the infants from their care and custody if they neglect these duties or act injuriously toward to their wards, the kids. They're calling your kids wards, and appoint others in their stead, or if they be permitted to remain, will force them to confer to the rules and regulations of the court in respect that care and custody, and punish them if they do not implicitly obey its directions. I'm trying to find out what that I don't know where it's at, but if this is something, I'm not gonna get into all this tonight, man. But if y'all want to read this stuff, go read it. This is how these people think. But this was again, just keep in mind, this was a long time ago. I'm saying this is when um the state so-called, I'm guessing this is from England or something like that, when the crown, the crown is sovereign over there or whatever. Ain't nobody sovereign over here except for the people. But anyway, I don't want to get into all that. Let me go back. I'm gonna go back to the chat and then I'm gonna get on up out of here, y'all, because I'm just tired. I'm already over my time limit right now for the night. Let me check this chat. Let me take it. Let me take this off. Turn this back on. I need to go to the barber shop. I'm tired. I need a haircut. Need some sleep. It trusts out from the Social Security Act. I didn't look it up yet, SG. I'm sorry, man. I didn't look it up yet. Lots of cases say the same thing. No room left for God in that triangle. What's the good name? Yes, sir. I try to keep an eye on the government. Haven't seen you page yet, Rogue Nation, but heard your name a lot on auditor videos. Hence why CPS can come and take your kids whenever they want. Well, I would disagree because they can't come and take it. They can't come from the public into the private and take them whenever they want. There are exceptions. Um, these exceptions would be exigent circumstances, your consent, or a warrant. Those are the exceptions for the public to come in and to have contact with the private. But I do get exactly what you're saying. Rogue Nation. I get exactly what you're saying. I agree, Steve. Stephen Z. I agree with everything you said, Stephen Z. And I'm of the opinion. I'm not against. Now, don't get me wrong, Stephen. I'm not against that. You feel me? But I don't believe what I'm against is the state saying that that your kids, your biological property belongs to them. That's what I'm against. Because no, it doesn't. But I do get what you're saying, Steve. And I would say like before the state intervenes in something like that, maybe a relative who the kid knows should should come in and do something like that. You know what I'm saying? Because I'm of the opinion that all parents are not good parents. All right, so I get it. I get it, and I do respect that. Yeah, I'm starting to get a little headache. Next time I go live, Steve. I like the way you talk, man. You articulate yourself very well. So we can have some conversations if you like. I don't mind. But I got to go. Yeah, I'm tired. I gotta go. So everybody enjoy your night. Hopefully this video helped y'all understand the distinction between general jurisdiction and limited jurisdiction. Um, if not, I don't know what else to tell you because I'll try again on another video or something like that. But anyway, that'll be it. Everybody enjoy your evening. The Supreme Litigant is out. Peace.